this day an opinion, a personal opinion, on the outcome in Roe? Do I have this day an opinion, a personal opinion, on the outcome in Roe versus Wade? And my answer to you is that I do not.
But do you think there is as fundamental a concern as legitimacy of the court would be involved if Roe were to be overturned?
Well, Mr. Chairman, I think that the legitimacy of the court would be undermined in any case if the court made a decision based on its perception of public opinion.
So a good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other.
Senator, I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years.
As Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
So fascinating stuff there. Fascinating stuff. I wonder if Alito or if Kavenaugh watched Clarence Thomas. And my answer to you, you asked me, do I have a personal opinion on Roe v. Wade? And my answer to you is that I do not. Why didn't you just say no? Why'd you say all of that just to get to no? No, I don't have a personal opinion except for, yeah, it should probably be overturned. Yeah, I have deep-seated beliefs that it should be overturned, and I've always thought it should be overturned, and I straight up lied to you. Alito, what a lying bullshitter. Kavenaugh is like, I said. Oh, is that what you well, you said it. That must make it true. Okay, well, I mean, you fucking said it. Okay. Roe v. Wade has been reaffirmed. Do you see how they get into all the fucking bullshit stories? Well, Roe v. Wade passed in 1973, and then the other decision, Glasberry versus Apple bottom jeans. Alito is a lying bullshitter. They're all a bunch of lying bullshitters. Let's look at Alito. You're trying to tell me that if you were a judge and you were sitting there, you know, or a boss and you were going to hire this guy, you would hire this fucking asshole? He sounds like a stuck-up asshole because he is a stuck-up asshole. He's a stuck-up asshole. He sounds like a stuck-up asshole who's lying because he is a stuck-up asshole who is lying. So, let's see. Alito, Roe v. Wade. See, confirmation hearing. How about that?
Our congressional correspondent, Quality Holman, launches day 2 of the Alito hearings.
Senate Judiciary Committee Chairman Arlen Specter knew this first day of questioning Samuel Alito could be an exhausting one for the nominee.
There are 18 of us and only one of you, so...
During 30-minute rounds, committee members repeatedly pressed Alito to reveal his legal thinking on issues such as abortion and presidential powers, and to clarify several personal matters. Chairman Arlen Specter, a supporter of abortion rights, got right to that with his first question.
Starting with the woman's right to choose, Judge Alito, do you accept the legal principles articulated in Griswold versus Connecticut that the Liberty Clause in the Constitution carries with it the right to privacy?
Senator, I do agree that the Constitution protects a right to privacy, and it protects the right to privacy in a number of ways. The Fourth Amendment certainly speaks to the right of privacy. People have a right to privacy in their homes and in their papers and in their persons. And the standard for whether something is a search is whether there's an invasion of a right to privacy, a legitimate expectation of privacy.
Specter then brought up the often-cited letter Alito wrote in 1985 in applying for a job in the Reagan White House, stating the Constitution does not protect a right to an abortion.
Do you agree with that statement today, Judge Alito?
Well, that was a correct statement of what I thought in 1985 from my vantage point in 1985, and that was as a line attorney in the Department of Justice in the Reagan administration. Today, if the issue were to come before me, if I am fortunate enough to be confirmed and the issue were to come before me, then I would approach the question with an open mind, and I would listen
So
to the
you would
arguments
approach
that
it
were
with an
made.
open mind, notwithstanding your 1985 statement?
Absolutely, Senator. That was a statement that I made at a prior period of time when I was performing a different role. And as I said yesterday, when someone becomes a judge, you really have to put aside the things that you did as a lawyer at prior points in your legal career and think about legal issues the way a judge.
So he's talking like an asshole because he's a lying asshole. So these are the things, everything I needed to know in life I learned in kindergarten. It's a poem by Robert Fulghum. And I believe this is a list. I don't know. Scrapbook.com says, here are the things I learned in kindergarten. Share everything. Play fair. Don't hit people. Put things back where you found them. Clean up your own mess. Don't take things that aren't yours. Say you're sorry when you hurt somebody. Wash your hands before you eat. Flush. Warm cookies and cold milk are good for you. Live a balanced life. Learn some and think some and draw and paint and sing and dance and play and work. Every day some. Take a nap every afternoon when you go out into the world. Watch out for traffic. Hold hands and stick together. Be aware of wonder. Be aware of wonder. Watch out the odds of wonder. When you go out into the world, watch out for traffic. Be aware of wonder. Hold hands and stick together. Okay, so Robert Fulghum, right? Share everything, play fair. Where does it say lie to the American people? Don't hit people, put things back where you clean up your own mess. Where does it say Alito, the judges can lie straight up to the American people? Say you're sorry when you hurt somebody, wash your hands, flush, warm cookies, live a balanced life, learn some, think some, draw, paint, sing, dance, play and work every day some, play, take a nap every afternoon. So there you go. There you go. I thought it was going to say, don't lie. But the 10 Commandments says don't bear false witness. So, yeah, Samuel Alito, how come you don't seem to live by Judeo-Christian values? You're a lying piece of shit. You're not supposed to bear a false witness. You lied about your own views. And you know what? I'm somewhat pissed off, but I'm also somewhat this is what they do. This is what they do. This is what they do. It's a partisan decision, so when the Republicans or Democrats pick their guy, basically it doesn't matter what the fuck they say as long as they don't fuck up. Go there, they're going to ask you a bunch of questions for a couple of days. The American people might be paying attention, but essentially the parties are going to vote on party lines, and maybe you might, turn this person or that person, but don't fuck up. Don't say, yep, I'm going to overturn Roe v. Wade. I sure as fuck am. Yes, sirree, I'm going to shred the damn Constitution. You ain't going to get any of your rights. You're not getting any of your rights. Reasoning in the Alito draft puts bullseye on other American rights. So that's interesting. We're sitting there listening to Alito say that we have a right to privacy. Well, not only is Roe v. Wade good law, but we also have a right to privacy, which is natural law. And Scalia believed in natural law, so they should listen to their conservative hero Scalia. But fucking Alito, I remember these goddamn confirmation hearings.
Inspector noted that the 1973 Roe v. Wade decision.
It's almost like
the woman's right to an abortion has been reaffirmed 38 times, and asked if it fell in the category of stare decisis, the principle stating that precedent decisions are to be followed by the courts.
When a precedent is reaffirmed, each time it's reaffirmed, that is a factor that should be taken into account in making the judgment about stare decisis. And when a precedent is reaffirmed on the ground that stare decisis precludes or counsels against re-examination of the merits of the precedent, then I agree that that is a precedent on precedent. Now, I don't want to leave the impression that stare decisis is an inexorable command, because the Supreme Court has said that it is not. But it is a judgment that has to be based taking into account all of the factors that are relevant and that are set out in the Supreme Court's cases.
Toward the end.
Well, I about fell asleep to that fucking answer. You lying piece of shit. You lying piece of shit. What all did he say? What is Alito's, draft on Roe, opinion? What did he say? They're saying that it's 10 key passages from Alito's draft opinion. You ready? Politico.com. It's labeled as a proposed majority opinion. We hold that Roe and Casey must be overruled. Yeah, they both mentioned Casey. Roe and Casey. Fucking bullshitter. Look, my original lie was this. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. So you don't have a right to abortion. Okay, we're not talking about privacy. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak. The decision has had damaging consequences, far from bringing about a national settlement of the abortion issue. Roe and Casey have inflamed debate, deepened division. It's time to heed the Constitution, return the issue of abortion to the people's elected representatives. In the years prior to Roe v. Wade, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restrictive regime on the entire nation, effectively struck down the abortion laws of every single state, represented the exercise of raw judicial power, sparked a national controversy, embittered our political culture for half a century. The inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. In some states, voters may believe that the abortion right should be even more extensive than the right Casey and Roe recognize. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. We have long recognized, however, that stare decisis is not an inexorable command. I remember Julie Chancellor, a fucking shitty teacher out of Louisville, Kentucky, who fucked me over out of $60,000 of my education. She was such a dickhead about you don't know what stare decisis is? Well, I was watching the Alito hearings, and he kept saying it over and over again. You fucking prick, you fucking asshole. I'm sure you were just born knowing all Latin phrases. I just heard, like, trunk and bunk. You know the trunk and bunk? Yeah, there's some kind of trunk and bunk, some Latin phrase, some bunkin' trunks Latin phrase, motherfucker. You ever heard that Latin? Let's find it. Trunk and bunk. Latin phrase. Trunk and bunk. Okay, whatever. So let's just look up Latin phrases. But the reason why she knew about it because of, this motherfucker. How about sapere aude? Ad astar per aspera. You don't know what ad astar per aspera is? Carpe venom. You don't know what carpe venom is? Motherfucker. So, yeah, there you go, you asshole. Just, you don't know what stare decisis is? Motherfucker, like, she's been talking about stare decisis her whole fucking life. Yeah, right. I'm sure she didn't tell me anything about what other precedents do you know? At least, goddamn Amy Coney Barrett knows about Marbury v. Madison and Brown v. Board of Education. Carpe venom means seize the wine. Ad astra per aspera, through adversity to the stars. Sapere aude, dare to know. Dare to know. Acta non verba, deeds, not words. Acta non verba. Acta non verba. Acta non verba. We have long recognized, however, that stare decisis is not an inexorable command. It's at its weakest when we interpret the Constitution. It said that it's sometimes more important that it should be settled than it be settled right. But when it comes to the interpretation of the Constitution, the great charter of our liberties, which is meant to endure through the long lapse of ages, we place a high value on having the matter settled right. On many other occasions, this court has overruled important constitutional decisions. Without these decisions, American constitutional law would be unrecognizable, and this would be a different country. Casey described itself as calling both sides of the national controversy to resolve their debate. In doing so, Casey necessarily declared a winning side. Roe certainly did not succeed in ending the division. On the contrary, we do not pretend to know how our political system or society will respond to today's decision. And even if we could foresee what will happen, we would have no authority to let the... Let's listen to some more Alito. And then what was Clarence Thomas straight up just lying?
Asked Alito to explain his dissent in the 1991 case of Casey versus Planned Parenthood, in which the Third Circuit Court of Appeals struck down a Pennsylvania law that included a provision requiring women seeking abortions to notify their spouses.
I did it because that's what I thought the law required.
But Wisconsin Democrat Herb Cole pressed Alito on Casey.
Judge Alito, in Casey, you argued that the requirement that a woman notify her husband did not impose an undue burden upon a woman. You reasoned in part that the number of married women who would seek an abortion without notifying their husbands would be rather small. In other words, only some women who would be affected. The majority in that case disagreed with you and stated, quote, whether the adversely affected group is but a small fraction of the universe, of pregnant women desiring an abortion seems to us irrelevant. The issue, unquote. This disagreement begs the question, is a constitutional right any less of a right if only one person suffers a violation, or should greater value be placed on that right if a larger number of people have that right violated?
Part of the problem was that the law just was not very clear at that time. The undue burden standard had been articulated by Justice O'Connor in several of her own opinions, and there were just a few hints in those opinions about what she meant by it.
It is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor to remember.
Well, Senator, Casey has set a law in the sense that it's a decision of the United States Supreme Court, right? And you also have a Obergefell and Lawrence. Those are all precedents of the United States Supreme Court entitled to the Wade precedent, which is quite considerable.
During their Supreme Court confirmation hearings in 2017 and 2018, Trump appointees Justice Gorsuch and Justice Kavenaugh both told the Senate Judiciary Committee that they understood...
Okay, so I was hoping he would get straight to the damn thing, but it seems like it's going to take a while. What else? What else? What else? Clarence Thomas. Let's go old school. Clarence Thomas confirmation hearing. Okay, here we go.
The hearing will come to order. Let me ask the Capitol Hill Police that there's not absolute order and decorum in here. We will recess the hearing, and those who engage in any outburst at all will be asked to leave the chamber. Good morning, Judge. Today, the Senate Judiciary Committee is meeting to hear evidence on sexual harassment charges that have been made against Judge Clarence Thomas, who has been nominated to be an associate judge of the Supreme Court. I want to speak very briefly about the circumstances that have caused us to convene these hearings. We are here today to hold open hearings on Professor Anita Hill's allegations concerning Judge Thomas. This we will review, and it is my hope and belief that my colleagues here today share that view. Achieving fairness in the atmosphere in which these hearings are being held
during the original confirmation hearings, this committee heard testimonies from over 100 witnesses, both for and against the nomination. Not one of these witnesses, even those most bitterly opposed to this nomination.
But since September 25th, I have suffered immensely as these very serious charges were leveled against me. I have been racking my brains and eating my insides out, trying to think of what I could have said or done to Anita Hill to lead her to allege that I was interested in her in more than a professional way, and that I talked with her about pornographic or X-rated films. Contrary to some press reports, I categorically denied all of the allegations and denied that I ever attempted to date Anita Hill when first interviewed by the FBI.
So we don't really figure out about, it's all titillating and whatnot, but we don't really figure out what he means by the right to privacy.
All my life felt such hurt, such pain, such agony. My family and I have been done a grave and irreparable injustice. During the past 2 weeks,
is that you actually do spend an awful lot of time today and throughout your career in law school classrooms teaching. For 6 or 7 years, you've taught a constitutional law seminar with a former clerk. Why have you seen that as something important for you to do with all the time that it takes to prepare?
I think you should learn constitutional law at some point, and I didn't. I could not figure out substantive due process. That really eluded me. So I could not figure out selective incorporation, partial incorporation, absorption. I mean, these things do not sound like technical terms to me.